So now that we're talking about property, something on mean profits, for example, is that something you come across in practice as well?
Yes, yes. We regularly come across mean profits, damages in a rent matter.
Okay, and usually you would say in India, laws favor tenants, right? Is that a fair description?
It totally depends upon the relationship and the lease deed
Yeah.
between the landlord and the tenant and the rent. Because if you see the Delhi Rent Control Act, it has a certain minimum rent,
Okay.
which if the tenant is paying, then he falls under the ambit and scope of the Delhi Rent Control Act, which in a certain manner is pro tenant.
Okay.
However, if you are beyond the Delhi Rent Control Act, and then it's just a mere contractual obligation, and then in that scenario, it totally depends upon the relationship. However, I would just like to add that these days the courts are in the favor of the landlord.
Okay. And you mean that even in the Delhi Rent Control Act, you obviously practice in Delhi, but you mean the favor of the landlord both under the rent control?
No. Only if you are outside the scope of the Delhi Rent Control.
So the Delhi Rent Control Act, the statutory provisions govern.
Yes.
So,
yes.
but why is it so difficult? We come across anecdotal evidence of people finding it hard to evict tenants. Why is it so difficult, basically? I mean, what would you do if a client came to you and said, okay, I have this tenant who don't come under the Delhi Rent Control Act. I'd like to evict him. He's been overstaying for so many months. So what would your advice be to him?
My first advice would be after reading the rent deed, the lease deed, would be to exercise the exit clause, which is the termination clause.
So all deeds will have a termination clause?
Should.
Okay.
Necessarily. We always advise for a termination clause, otherwise it can just go into perpetuity.
Yeah.
But as you asked me, we would definitely like to exercise the termination clause, and then subsequently, in accordance with the termination clause, we would serve a notice for termination of tenancy upon the tenant.
This is outside the ambit of the CPC at this stage, yes?
Yes, you could say so. I mean, it's not really outside the scope of the CPC. The CPC has still not kicked in.
It's not kicked in, yeah. But when it does kick in, your notice of termination is important.
Yes.
Why is that?
That's because to end a contract, you need to give the other person that notice that you have ended the contract from your end.
So yeah, it's a contractual relationship at the end of the day.
Yes,
so now coming to mean profit specifically, how does it work in practice? So if your client wants mean profits, would you say, okay, first we have to prove that there was a tenancy, there was an agreement, or do you just approach the court and say, look, he's in possession?
No, it works in a three-step procedure. First, we obviously issue a notice for termination of tenancy. We ensure that it is received at his end.
And how do you do that? Sorry to interrupt.
We usually send it by two modes.
Okay.
A courier as well as a registered AD.
Okay.
And usually we keep a POD, postal delivery receipt with us.
Okay.
And we check whether that has been delivered at their end.
Okay.
Same with the registered AD. The AD card will probably come back to you.
Okay.
So that is enough proof that it has been served upon the tenant, number one. Then the second procedure is, in case he replies or does not reply, he doesn't vacate.
Yeah.
That is the main.
Yeah.
That is the main aspect of it.
Yeah.
That is when we go to court.
Right.
And we file a suit for possession, mean profits and damages.
Okay.
In terms of suit for possession,
yeah.
As the name suggests, we are asking for three basic reliefs: possession, mean profits, and damages.
Okay.
Now, when we go to court, we have to prove four things to begin with. Number one, there was a lease deed. Number two, there was a specific rent in the lease deed, which the tenant was paying to the landlord. Thirdly, the lease deed had a termination clause and had a tenure basically to it. Fourthly, we actually served a notice for termination of tenancy upon the tenant.
Okay.
Now, if these four things are proved in a court of law, the judge will accept the plea that this is an admission on the part of the defendant or the tenant that he's accepted all four. Then we move an application under Order 12, Rule 6 for passing a judgment on admissions.
Yeah.
And subsequently, the judge will realize that at least as regards the relief of possession, he should go.
Yeah, you can get him, you can evict him.
The tenant should go because the contract has been terminated.
Yeah.
He has no further right to stay in the property,
Right.
and therefore he will pass a judgment
On admission.
based on admissions.
Yeah.
And in accordance with sub-rule 2, he'll probably pass a decree, which will be a
A
preliminary
decree, which will be a preliminary
Preliminary
decree
decree.
subject to mean profits and
Absolutely.
judgment. So that's how it all.
The damages and mean profits will obviously continue to be contested
Yes.
once the preliminary decree
That
has already
takes
been
time
passed.
though.
Yeah,
anyway.
that takes time.
Okay. Thank you.
Yes.
That was helpful.